5 seconds to go. Start. This appeal is at the instance of the original complainant, husband of the deceased, and is directed against the order passed by the High Court of Jammu and Kashmir at Srinagar, dated 26 November 2020, in the CM M number 99 of 2020, by which the High Court rejected the revision application filed by the appellant herein, thereby affirming the order passed by the additional sessions judge, that is trial court, discharging the original accused persons, respondents numbers 1 to 7 herein, from the offence of murder punishable under section 302 of the Indian Penal Code, for short IPC. Upon affirmation, the trial court proceeded to frame charge against the accused persons for the offence of culpable homicide punishable under section 304 of the IPC. It appears from the first information report bearing number 26 of 20, dated 22nd March 2020, lodged by the appellant with the police station, that on the fateful day the accused persons formed an unlawful assembly and laid an assault on the appellant and his family members after trespassing into the residential property of the appellant herein. It is the case of the prosecution that all the accused persons trespassed into the residential property of the appellant and started damaging the tin fence. When the appellant herein tried to restrain the accused persons from causing any further damage, they all started assaulting the appellant by giving fisticuffs. One of the accused persons is said to have hit the appellant with a wooden log. The wife of the appellant herein and his daughter-in-law came to the rescue of the appellant. The accused persons are alleged to have caught hold of the deceased, wife of the appellant herein, and the daughter-in-law, and both were beaten up, causing injuries. It is further alleged that the two female members of the family were dragged by the accused persons. As a result, the clothes of the deceased got torn, thereby outraging her modesty. In connection with the aforesaid incident, the appellant went to the police station and lodged the FIR. The FIR was initially registered for the offences punishable under sections 147, 354, 323 and 451 respectively of the IPC. The deceased wife of the appellant had to be shifted to a hospital as she suffered injuries on her body. No sooner the deceased was brought to the hospital than she was declared dead by the doctor on duty. In such circumstances, section 302 of the IPC came to be added in the FIR. The post-mortem of the body of the deceased was performed. The statements of the various eyewitnesses to the incident were recorded. Various panchanamas were drawn. At the end of the investigation, the police filed charge sheet against the accused persons for the offence of murder, along with other offences as enumerated above. The cause of death of the deceased, as assigned in the post-mortem, is cardiorespiratory failure. No poison was detected in the viscera. Stop.